Good afternoon, everyone. Good morning to Jens. And welcome to the second online workshop, business law workshop in Trinity term. Today, it's our great pleasure to have Horst Eidemüller and Jens Daman together presenting their joint work on whether you can transplant codetermination in the US. You have seen the working paper on SSRN. As usual, we will have a presentation, which I guess the presenters will have no problem being interrupted by questions if there are any. If that's not the case, just let us know. And there are various ways by which you can ask questions. You have the Q&A function. You can raise your hand, and possibly you can also jump in, but that's not the best way to do it. As last time, we are promoting attendees to panelists as we see them and as we recognize them as part of the broader Oxford Law community. So without further ado, I would ask Horst or Jens to take the floor and start the presentation, thanking them again for accepting the invitation.
Okay, thanks so much. So I'm going to do the first part of the presentation. Can everybody hear me? Okay, perfect. Thanks so much. So first of all, we're very grateful to be able to present here. And of course, we love your feedback on the paper. So that's a great opportunity for us. Now I'm going to share my screen and hopefully that works. All right, perfect. So, so that took a while, but now we're here. Okay, so there's a particular reason why we're talking about this topic now, codetermination as a fit for US corporations. And the reason in a nutshell is that two very prominent US politicians, Elizabeth Warren and Bernie Sanders, have both presented plans to subject US corporations, large US corporations, to mandatory codetermination. And their proposals are loosely based on the German law of codetermination. We're going to talk about a bit more about that shortly. And this paper therefore looks at the costs and benefits of making codetermination part of US law. And the key argument we're making here is that codetermination may well be suited for Germany, but the advantages of codetermination are likely to be less pronounced in the US than they are in Europe, whereas the costs are likely to be higher. So I want to stress this point because it's crucial to the paper. Obviously, codetermination has its fans and it has its detractors, but we're not trying to answer the question, is codetermination in Germany good or bad? That's not the point. What we're really trying to look at is we're trying to focus on institutional differences between Germany and the US, and we're arguing that whatever suitability codetermination may have in Germany, it is probably going to do substantially less well in the United States. And, concluding, we then say, well, while codetermination may or may not be a good fit for Germany, it probably isn't a great idea for the US corporate landscape. All right, so I promised to talk a little bit more about these policy proposals. Again, they're by Warren and Sanders. Of course, they're no longer in the running for president, but who knows, right? Vice president might still be on the table for one of them. And either way, it doesn't matter so much in the following sense, right? So we've seen that some political ideas really have become the mainstream of the progressive, left in the United States, right? So Medicare for all was a weird slogan a few years back, and now it's kind of firmly part of the liberal part of the Democratic Party. So the question is, will the same be true for mandatory co-determination? Now, the Warren and Sanders proposals are somewhat different, right? Warren focuses on gross revenues, and she wants to subject firms with, more than $1 trillion in gross receipts to co-determination. Sanders wants to subject all publicly traded firms to co-determination, or firms that have more than $100 million in annual revenues, or firms that have more than $100 million in their balance sheet total. So it's somewhat different. They also differ somewhat regarding the amount of board seats that they want to reserve for worker representatives. For Warren, that's 40%. Sanders goes slightly above that with 45%. But, they're really not that far apart, especially if you look at, if you run the actual numbers and see, what would happen if we implement CompuStat database. And if you look, if you apply these criteria, so I got to align with the camera here. If you apply these criteria and you want to figure out how many firms would actually be subject to that, then you can see that, yes, with respect to the number of firms, that makes a very substantial difference, right? So Sanders has, the Sanders proposal would apply to more than twice as many firms. If, on the other hand, you look at the number of employees covered, the difference becomes a little smaller, right? There it's 31 million versus 29 million. And we've contrasted all that with the criterion employed by the 1976 German Co-Determination Act. So we've, taken the worker threshold there and applied it to U.S. corporations. And that's actually slightly in between the two proposals, right? So that's closer to the Warren proposals, but has slightly more firms than the Warren proposal, but has substantially fewer firms than the Sanders proposal. So, why is this useful? It's kind of useful, when people heard the Warren proposal and the Sanders proposal, said, well, but that's only for very, very large firms. Well, yeah, true, but you're right. It's not that different actually from what German law is doing these days. All right. So the paper also talks quite a bit about the empirical literature. I don't want to talk about that in too much detail now during the presentation because it's a bit too technical for that. But the upshot in our view, right, the main takeaway is here that even after decades of research, there hasn't really no real consensus has emerged, right? So first of all, a lot of the papers are can be challenged regarding their methodology, but also the outcomes are somewhat contradictory. So we've seen some papers say, well, this is actually good for firm performance, and others said, well, it's slightly bad for firm performance. So it's, the empirical evidence is a bit inconclusive. Now, what are the benefits of co-determination? This is obviously, since we don't believe the empirical evidence is so good, this is sort of where, the theory on co-determination comes in. And so one of the classic benefits that is said to be advanceable in favor of co-determination is that it reduces the cost of collective bargaining, right? So what is that really? Well, imagine it this way, right? You have the firms and you have the unions bargaining over wages. And the problem here is that the employers will always claim that times are bad and they really can't raise wages and the unions don't trust them. And the employers may not have a way of signaling in a credible fashion what their true financial status is and how they really view the future. And then the results may be very costly strikes. And by having employee representatives on the board, especially if some of them have to be union representatives, well, that could be a really good way of reducing the informational symmetry between employers and employees. And, in this case, employers generally and unions. and that could really sort of reduce the cost of strikes. And, you know, we have no doubt that this actually plays some role, but if you look at the weight of this consideration, right, you want to compare how many people are actually covered by collective bargaining agreements, right? So if this is great for reducing the cost of collective bargaining, then the importance of this factor will depend on how much collective bargaining there is, obviously. And, you know, this just varies drastically across nations. So if you can see for Germany in this table, right, that's somewhere in the middle there, the middle column about, you know, 2015, those are our newest numbers. We have 51.2% of private sector employees covered by collective bargaining agreements, whereas, you know, for the UK and the US, the numbers are just strikingly lower, right? I mean, for the UK they're somewhat lower, but for the US, they're dramatically lower at 7.4% in 2015, 7.3% 2017. So, you know, even if that is an advantage, right? Even if collective bargaining, if the costs of collective bargaining are reduced by codetermination, that's just not going to have the same impact in the US. Okay. So there's also obviously other benefits, right? So, you know, one potential upside is that firm-specific investments can be encouraged by codetermination. You know, what's the idea here? The idea is that you really want employees to invest in their relationship with a firm, for example, by acquiring firm-specific expertise, and they're not going to do that if they think they're just going to be exploited afterwards, right? So imagine you have an employer, and the employer will say, well, it's great that you acquired all this expertise that's relevant to my firm alone, but I'm not going to pay you more because, let's face it, you have no options, right? You can go to the competition, but, you know, it's sort of the nature of a firm-specific investment that is only relevant to my firm. So really, my competition is not going to appreciate all the expertise you've gathered, and therefore, why should I pay you more? That's sort of, you know, the kind of conflict that we're looking at, and codetermination can arguably reduce that conflict because it can allow boards to send a more credible signal that they're not going to take advantage of the employee. Now, the question is, you know, how would that benefit play out in the US? Would that be more substantial, less substantial? Our main point here is really that, well, you know, it's important to remember that codetermination may be one such mechanism, but really German law has just much more detailed employment law rules. So you can't just take one rule out of a big bundle and then expect that to do the heavy lifting. So unless you also want to copy, you know, for-cause termination rules, meaning, you know, if you want to ban firms from hiring and firing at will, if you want to copy firm-level codetermination, meaning, you know, the works council, that sort of thing, then just copying one element, you know, may not do much good. Okay. So obviously there are other benefits, you know, there are non-pecuniary benefits, you know, there's the whole human dignity, democracy aspect. Let's see, I'm kind of, well, yeah, I can speak for one or two more minutes. So obviously, right, different people like different things about codetermination, right? If you believe that codetermination is an essential prerequisite for protecting human dignity, and if you take a natural law kind of approach to this, then you will like codetermination wherever it takes place, right? You'll say, well, this is just by definition an important step towards protecting human dignity. Why should that be different in Germany or in the US? That's what send us more and have in mind as well. So, you know, sort of a strict natural law kind of approach to human dignity kind of has a hard time explaining that. If you're looking at more functional aspects, right, so, you know, it has been suggested that, you know, workers are trained in democracy, you know, we have to practice voting, so to speak. It's not an awfully strong argument today, especially in the United States. Now, if you've ever lived in the United States, you know that Americans vote on pretty much every office that's out there, right? Not just the important stuff, every, somewhat important county clerk is elected by voting. So do we really need more elections? Probably not. Do we need, is this something that really responds to workers' dignitary concerns today? Again, we don't think that's a realistic account. We think today it's really outsourcing, right? That's sort of the main dignitary concern. The problem is, workers don't complain because they're part of a large organization. Today, what we're seeing is workers being outsourced as, quasi-independent contractors where they have no economic security whatsoever. We've seen this during the Corona crisis now, right? That people who are not working for a major employer have little that offers them against the crisis. So we think, the sort of dignitary concerns, whatever, way they may have had at some point, are really probably not responding to something that's a major concern in the US right now. And I want to stop here and hand the presentation over to my co-author, Horst Eidenmüller, and he'll take it from here.
So first thing, can you hear me?
Yes.
Okay, good. Now, Jens, there are a couple of questions in the chat. Actually, I think 3, which come from Luca, basically, and then Yoon. And I think we are best positioned to answer these questions. So John is asking, what sort of percentage of US public companies are these would be affected basically by the Sanders and Warren proposal?
Yeah, so the Sanders proposal, since he explicitly wants all public corporations to be subjected, right? That's 100%. We've just taken all public corporations. The only ones we've picked out for the Sanders proposal, because he says he's explicitly only speaks about corporations, so we haven't included publicly traded partnerships and publicly traded LLCs, but there's only a small handful of those. So, sort of think about them, send us to all public corporations. And, then of course the Warren, let's see if I can get actually real quick. So the Warren proposal, that's about half of those, right? Somewhat less than half of all public corporations. What's the second question? I can't see the question. I don't have
okay,
even
so
in my
I
chat
tell
function
you,
that I'm
so the second question is by Luca. Do you have any wake up in terms of sectors, services, manufacturing, tech, etc. for these firms to be covered by the proposals?
So we haven't done that. We can easily include that. That's a very good suggestion, obviously, because they're only looking at quantitative criteria, right? This would be driven by, which industry has large firms versus small firms. And, there may very well be differences.
Okay. The third question is by Yoon. Isn't the goal of Warren or Sanders also to increase collective bargaining?
So that's an excellent point, right? So obviously, sort of, one of our arguments is that, codetermination is not going to work as well because there's less collective bargaining. And the counter argument to that might be, well, but we're really trying to transform the US towards looking more like Germany, right? In the sense that we can't say that a lot, but, looking more social democratic in a way, right? And we want there to be more collective bargaining. And this is a step towards collective bargaining. And, no doubt, right, that once you have collective bargaining, especially, once you have codetermination the way you have in Germany, where, one of the representatives has to be a union member, right, that strengthens, labor unions to some extent. And so that might lead to more collective bargaining. But at this point, sort of to expect that there will be a role for collective bargaining that's even close to what we see in Europe, I think that's quite far off. So even with a very progressive presidency, right, even if they're trying to strengthen collective bargaining, which they may, right, they may increase protections for labor unions, which have been dismantled over the last, decades. even if you change that, right, it's probably not going to go to European levels anytime soon.
Okay. And then there's a fourth question by Josh. What are the origins of German codetermination? Does it predate the post-1945 settlement, i.e. the Weimar social democracy? Was it already present in the Weimar social democracy, or was it part of the post-war reconstruction? And if it was good for Germany, why did the UK and the US not also embrace it more thoroughly? Origins count. Now, I can give a first shot on this, and Jens, you probably are able to add more stuff on this one as well. Now, Germany has a long tradition of workers' involvement in the running of businesses in the form of works councils on the shop level. And that actually dates back to the Weimar Republic, and even before the Weimar Republic, there were first signs of that emerging. So that's an institution that's more than 100 years old. And that was kind of a role model for many other similar institutions in other countries. Codetermination on the board level and employee involvement is in fact a post-war phenomenon. It is not a pre-Second World War phenomenon, and it is part, in my view, of what you consider to be the post-war reconstruction of Germany. And you can see this also with respect to an issue that we already touched upon, namely the issue of bringing democracy and democratic modes of acting to the firm. So the idea to democratize all levels of human society, including large firms and their government on the board level, is one that's distinctly post-war, I would think. Jens, I wasn't sure whether you would agree with this.
Oh, I absolutely agree. So specifically on the first statute on codetermination post-war was the Coal and Steel Codetermination Act that was limited to the coal and steel industries. And what happened there was really that the coal and steel industries have been viewed as instrumental in the rise of the National Socialists, of course, and in the war effort. And so the idea was, that these should be decartelized, right? Those formed cartels. And the industry was essentially told, look, you have to decartelize. And they said, well, isn't there anything else we can do? So, codetermination was sort of an alternative decartelization of an industry that was thought to be untrustworthy and that, needed more control. So everything that Horst said, I completely agree with, right? This can be seen in a specific historic context of trying to bring, democratic control.
Okay. So I will then carry on, and I will also try to share my screen with you and see whether this works. Okay, but I don't have the, okay. Right. So Jens has introduced the paper and also spoken about the empirical literature on codetermination and the benefits of codetermination, and has tried to make the case that benefits that might accrue in Germany are probably not accruing to the same extent, or wouldn't accrue to the same extent in the United States if codetermination were exported, quote unquote, to the US. Now, I'm going to try and make the case that the costs of codetermination probably would be much higher in the United States than they are in Germany. That these costs exist, I think, is undisputed. The question is the magnitude. And our main point here in this section of the paper is that the magnitude is likely to be much higher in the United States. And we discussed a couple of issues in this context. The first one being what codetermination does to the functioning of the board. And we're trying to argue that it might impede the efficient functioning of the board because employees and shareholder representatives, of course, have pretty conflicting goals in terms of what they want to achieve with the governance of the corporation. And because of these conflicting goals, the main function, or one of the main functions of the board might be impeded, namely that there might be much less effective monitoring of managers, and as a consequence, higher agency costs. Now, we also try to argue that if this is a problem, we believe it is likely to be much more severe in the United States, because as most of you, all of you probably know, in Germany, there's a mandatory two-tier system for the board with respect to stock corporations. So they have a management board and they have a supervisory board, and there's no choice for stock corporations to do a one-tier or two-tier system. They have to have a two-tier system, and codetermination is implemented in the supervisory board. So the day-to-day management of the corporation is done by the management board. And if there is a conflict of interest between shareholder representatives and employee representatives, in Germany it plays out in the supervisory board. It doesn't affect really the day-to-day management of the corporation to a significant degree, but it would, of course, to a much higher degree in the United States in a one-tier system. So it does make probably the efficient functioning of the board less efficient in terms of its functioning, and the problem might be, or would be more severe in the United States than it is in Germany. The second point we're making is that codetermination as on the board level as an institution makes it almost inevitably more difficult to remove directors which perform not as well as a director should perform, or are even incompetent. Now, that of course is related to the question, how are the worker or employee representatives on the board, either the one-tier board, management board, or the supervisory board appointed? Usually that happens by some kind of voting mechanism by which the employees vote, and usually there are certain significant majority requirements. So in Germany, for example, it is the case that an employee representative on the supervisory board can be removed only by a 75% majority of those voting employees. And that's, of course, a significant threshold. And if you have a situation where apparently a board member or more than one board member doesn't perform well, it will, of course, be exceedingly difficult to remove that person and to mobilize significant support amongst the voting employees to get that person removed from the board. Now, again, because codetermination plays out in a German stock corporation on the supervisory board and not on the management board, which does the day-to-day management of the company, the problem is likely or would likely be much more severe in the United States in the one-tier system. Our third point relates to the governance of corporations in financial distress. And that's something that in good times, of course, is not a significant issue to be concerned with, but in bad times, and we are in severely bad times right now, that may play out in a significant way. Now, the argument here is as follows. Codetermination in a German stock corporation affects the governance of a firm in good times. But it doesn't affect the governance of the firm in bad times, because if a German stock corporation enters formal insolvency proceedings, in 99% of the cases, an insolvency administrator is appointed who takes over the running of the firm, superseding, and this is the key point here, superseding the governance mechanisms that exist outside of bankruptcy proceedings. So the management board and the supervisory board are no longer the institutions who are in charge with running the stock corporation. Rather, it is the insolvency administrator who is constrained by the institutions that are defined and empowered in the insolvency code, but he's not constrained by the competencies of the management board or the supervisory board in good times outside of insolvency proceedings. That means basically that codetermination doesn't inhibit or impede rapid action, managerial action in an insolvency process, because the insolvency administrator basically is unconstrained by these codetermination rules. Now, in the United States, the situation is very different, as you know. When a US corporation enters Chapter 11, in 99% of the cases, the debtor stays in charge, and the mechanisms of governance that exist outside of bankruptcy are the mechanisms of governance that exist within bankruptcy as well. It means that the board has a little bit different duties in a bankruptcy proceeding, but the board is still in charge of the operations of the firm. And if we implement codetermination in the United States, that would mean that bankruptcy governance will also be impacted by the codetermination rules. Now, you can make, of course, arguments now from this going in either direction. You can say, well, if we think codetermination is a good thing, then of course it should play out in bankruptcy as well, because after all, crucial decisions about the future of the firms are at stake, jobs are at stake. So it's just fair and okay to have workers have a say in what's going on if the firm is financially distressed. On the other hand, I mean, it is absolutely clear that in a bankruptcy situation, you also have a necessity to act quite rapidly under certain circumstances and to take economic decisions, hard decisions, relatively quickly to seize an opportunity, for example, to sell the firm as a going concern, et cetera, et cetera. And that is one of the reasons why probably the German approach in this context is not bad, to say, okay, in an insolvency setting, we don't want to have codetermination. So if you give more weight to these economic considerations, I think that's probably the better approach than in the United States. If codetermination were introduced, we would have a significant problem with respect to bankruptcy governance. Now we are discussing two further aspects that are costs of codetermination, and try to think about how the magnitude of these costs would be if codetermination were implemented in US corporations. The fourth aspect is the market for corporate control. Now, again, as all you know, the market for corporate control plays a non-trivial role in keeping managerial agency costs in check. The threat of a corporate takeover is something that induces the incumbent management to try as best as they can to maximize firm value, to reduce the threat of a hostile takeover. That's an idea that goes back many decades. And there's no denying that an effective market for corporate control plays some role in reducing managerial agency costs and putting pressure on the incumbent management to manage the firm as best as they can. There's also no denying, of course, that employees usually, in a situation where a company is potentially taken over, are opposed to such a takeover because they, at least a significant portion of them, potentially tend to lose their job if that happens. Massive upheaval and restructuring usually involved. So employees are no big friends of corporate takeovers. The other thing I think that's fairly straightforward to note is that whether one likes corporate takeovers or not, there is a vigorous market for corporate control in the United States, and there's no such vigorous markets in many European continental. So takeover activity in Germany has always been much lower the level than in the United States. Now, if you take these things together, and if we exported German codetermination on the board level to the United States, we likely would have a situation where the existing vigorous market for corporate control in the United States would be significantly reduced in its volume and also in its beneficial effects in terms of the reduction of managerial agency costs. Now, our fifth point is the potential reduction in the flexibility of corporate law. Now, if one introduced codetermination on the board level, or if one introduces codetermination on the board level, you usually, of course, if you're a prudent lawmaker, have to think about whether the law that you're introducing is watertight or whether it invites circumvention, and if so, how you can prevent circumvention. So basically, just enacting a requirement that firms that pass a certain threshold should have mandatory codetermination on the board level usually doesn't suffice. You have to also legislate to prevent certain forms of circumvention. And that this is a significant risk is shown by the European, more specifically the German experience. So if, for example, one would be subject to a mandatory codetermination regime, then the question for a corporation in the US would be, okay, now shall we reincorporate to another jurisdiction in order to get rid of the codetermination requirement? And that kind of consideration played out on a significant scale. In Germany, there is quite an amount of literature on the European stock corporation, the Societas Europaea, and why it has become so popular amongst German firms in particular. And the upshot of this literature is, the empirical literature, is that the Societas Europaea has become so popular in Germany because it is an interesting vehicle to either completely avoid the German codetermination rules or at least diminish their effect. I don't want to go into details here, but this is well documented. And it shows what corporations which are affected by codetermination requirements might do if confronted with these requirements. Let me try to reincorporate in another jurisdiction. Now, why would this problem potentially be much more severe in the United States than in Germany? That has to do with the applicable tax system. So if a German corporation, for example, reincorporates into the UK, but retains its principal place of business in Germany, and it's just becoming an English corporation by virtue of this reincorporation process, it still will be taxed basically with its worldwide income in Germany. Now, situation in the United States appears to be different. I'm not a tax expert, but my understanding is once that happens, then only the US income would still be subject to the region. And that means that the incentive to reincorporate is greater because of the differences in the tax system in the United States, or would be greater. There are other forms of potential circumvention that could arise. So firms could try to convert into other legal entities that would not be covered, domestic legal entities that would not be covered by the applicable codetermination regime. So, for example, to limited liability partnerships, they are not within the ambit of the Sanders and Warren proposals as they have been formulated. Or firms could tweak and twist with their corporate charters and bylaws to get around certain of the requirements of the codetermination regime. So there are all kinds of things that firms could try to do in order to circumvent new legislation on codetermination on corporate boards or to moderate its effects. And that means one would, as a lawmaker, or one is forced more or less to try to do something about these forms of circumvention, and that can only be done by introducing mandatory rules that try to prevent regulatory arbitrage to the extent possible. Now, the point that we are making in this section of the paper is that the cost of preventing regulatory arbitrage in the US would probably be higher than they are in Germany. Why? Well, because in Germany, stock corporation law is mandatory law anyway. So the basic principle enshrined in section 23 of the German Stock Corporation Act is that all rules within the code are mandatory unless provided otherwise. Now, the legal starting point in the United States is, of course, quite different. The traditional character and the spirit of corporate laws in the United States, Delaware and others, of course, is that they're enabling. They're not mandatory, they're enabling, and they give a lot of freedom of contract to those engaged in a business enterprise. And because of this different starting point, if the United States were to introduce mandatory co-determination on the board level, and if further mandatory rules would be introduced to prevent circumvention, the shift in character of the applicable corporate law rules would be much more severe in the United States than in Germany, where the starting point is a lot of mandatory laws anyway. Now, finally, and that's the last point that we are discussing about the costs of a co-determination regime, is the effect it would have on beneficial risk-taking and how that effect would differ in the United States compared to Germany. And our point here is that we probably would see a reduction in beneficial risk-taking, and that reduction in terms of beneficial risk-taking plays into a cost of co-determination, and because the level of risk-taking is higher in the US anyway, the costs of introducing a mandatory co-determination regime would be higher in the United States than in Germany. Now, the starting point for this analysis is that, at least if one starts from the premise that shareholder wealth maximization is a sensible idea that requires pursuing projects with the highest net present value, regardless of the risk level, because shareholders can diversify anyway, so there's no need for businesses to be cautious in their approach. They could and should go actually for the kinds of projects and investment that produce the highest net present value, independent of the associated risk. Now, it is also pretty straightforward to take as a starting point for the further analysis that employees tend to oppose very high risk investments because they do not participate in the upside. And if the downside materializes, i.e., if not everything goes well, then they lose their jobs. So prudent, but also not prudent employees usually, of course, tend to prefer an investment which might have a lower net present value, but that is reducing or comes with a lot less associated risk. Now, introducing mandatory co-determination on the board level and giving employees a say in the kinds of projects that the corporation pursues is then almost inevitably reducing the kind of beneficial risk-taking that is associated with this notion of companies should pursue the highest net present value projects. Now, we should also note, or one should also note that the United States institutional environment is much more geared towards allowing even extreme levels of risk-taking and coping with failure in the context of extreme level of risk-taking because of a variety of institutional circumstances, such as it has the most developed capital market in the world, that it has a large number of skilled VC firms that have a long history of being involved in significantly risky investments and transactions. And the size of the economy is such that even if a large public corporation fails, that doesn't really shatter the economy. Whereas in a smaller economy like Germany, for example, which has much less of these institutional safeguards to accommodate extreme forms of risk-taking, failure would be felt much more severely. So introducing mandatory codetermination on the board level in the United States would probably reduce beneficial and even extreme risk-taking that is beneficial to a significant degree in the United States, and much more so than it has done or is doing in Germany. So our conclusion then is the following, and that ties back to what Jens has said in the beginning. We come to the conclusion that the institutional, social, and economic environment in the United States and Germany are very different. And that leads to the conclusion that some of the core benefits of codetermination are unlikely to materialize in the United States. And at the same time, the costs of codetermination are likely much higher, or would be likely much higher in the United States than they are in Germany. Now, a notion of caution, of course, the key argument that we are making depends on exactly the institutional, social, and economic environment in the US and how it differs from the environment in Germany. And these things are susceptible to change, and they do change. However, they don't change overnight. And we do not see, at least in the foreseeable future, that they would change so significantly that our analysis that we are submitting would be massively effective. And that's how we conclude our paper.
Thank you, Horst and Jens. There are three questions, I think, two from John and one from Josh in the chat that you may start with. Everyone is welcome to raise their hands or post comments on the chat or in the Q&A section.
Okay, so I'm still trying to organize my technology here. Jens, if you can see anything in the chat and want to take a first shot on the questions, go ahead, please.
Sure. Yeah, so I can see the chat now. So and I have lots of extra feedback. I'm just going to, start picking at them while you're still busy. So first of all, somebody mentioned that in New York, the collective bargaining situation in terms of coverage rates might not be all that dissimilar to the US. So in New York and California, so that might be interesting in terms of thinking about, possibly not doing a uniform solution for the US, right? You could sort of maybe codetermination might be a more plausible solution for some states than for others. Another concern there, of course, is that, we have, the internal affairs doctrine in the US. So you would have to impose it as a real seat doctrine. And we've seen that with the gender quota for corporate boards, right, in California, right? So the question is, could you do something similar for nation? Just for some days? That's something worth thinking about. Then John raised the question and said, well, if you don't like the combination of one-tier boards and determination, why not simply give them the option to make two boards, right? The two-tier board system, and then problem solved. And I think that's a very good question as well, right? So this is kind of a leitmotif throughout our paper, right? That we say, well, there are important differences between the two countries, and they are less useful in the US. And of course, you can always ask the question, well, couldn't we make the US broadly more similar to German corporate law? And so I think sort of John's argument raises the valuable point that, yes, you probably could make some adjustments to US corporate law that make codetermination less damaging. But that sort of runs into our other concern that is one of the costs of introducing codetermination, right? So the US, right, would there be sort of long-term damages, indirect damages, if we switch to a two-tier board system? And also John raised the question, well, what about, so in terms of the risk-taking, right? So we argued that there's too little risk-taking of the useful sort under codetermination. And John said, well, what about firms where sort of the employees have, at least that's how I understand the question, where there's sort of, broad-based stock incentive plans. That's also a very good point. Now, you could imagine an extreme case, right? So you could imagine venture capital firms, not venture capital, startup firms, where literally everybody is sort of an entrepreneur, right? Every guy working there, every lady has stock options that they're there. And that's where, in fact, right, sort of giving workers a say might have the least damaging impact on risk-taking at the firm level, because that's why they're there for. And the answer is, yeah, but those are also the firms that are somewhat exceptional, right? And they're least likely to be covered by codetermination if we focus on size, right? They're also not necessarily publicly traded yet. For large firms, there'll always be a huge discrepancy, right? If you're a worker at General Motors, right, all your eggs are in one basket, right? You work for General Motors. Your house, the value of your house is tied to the fact that that there are lots of jobs there in town. If General Motors closes down, that's lost. So workers will be substantially more cautious, even accounting for some sort of stock options. And I think Horst is back online. So I think I'll leave the next couple of questions to you.
Okay, thanks. Now, the next one, if I got this right, is Josh. On assessment and control of insolvency risk, is there a parallel story about German, UK, and US bank representation or management displacement controls as external financiers monitor to protect collateral? Now, Josh, could you elaborate a little bit on this, because I kind of have slight difficulties understanding where you're going at with this question.
Can you hear me?
Yeah, I can hear you.
Okay, well, yeah, my question was totally mangled, so let me try again. People in Anglo systems are dimly aware that banks have a formal role on an external board to monitor collateral. And I mean, Oren, I think, is with us. He's done, with Colin Mayer, lots of research about how banks lending to corporations have triggers, covenants, and can monitor from outside and take over companies if directors start to do wild things as their company gets into trouble and threaten the capital base. The banks can intervene. So there are different ways in which external finance can protect itself. So I suppose one folk myth is that German banks stabilize German capitalism and give them longer time horizons, give the corporations longer time horizons, because they work more closely with the directors. They're more skilled and knowledgeable in local capitalism, kind of Mittelstand capitalism, knowing their businesses. They're not just doing actuarial finance. It's not as depersonalized, and this is a benefit to German capitalism. Now, this may be a myth and may be proven that there aren't such great differences between Anglo and German systems. But if there's a kind of a banking finance codetermination culture going on the capital side, don't we have to put that on the table? Because you're arguing that we can't transplant German codetermination on the labor side to the Anglo societies because there are so many different conditions. But surely one of the big elephants in the room would be a totally different role for banks providing external finance in the two different orders. So that was what I was trying to telegraph in my mangled question.
So if I understand you correctly, what you're saying is German codetermination has something to do with labor and capital working together in a firm. And we also have external financiers like banks and the corporation, the recipient of external debt financing working together more closely maybe than the culture in the United States would permit.
And another note, one of my favorite books teaching me in this area is Grant Gilmore's Personal Property and Finance Treatise from Chicago. And he tells a story before the UCC in 1960 and floating finance was introduced into American systems. Banks actually had to put accountants into corporations to maintain priority. They had to sign capital in and out, which makes functionally the way in which banking related to corporations in America look functionally similar to Germany. And the idea is that once you move to floating finance, you have techniques to be able to protect your collateral without being involved in the company.
So on a very abstract level, I think one might be able to say that if you've got a culture of collaboration within an economy, very abstract concept, that of course can play out in various more granular institutions related to corporate governance, such as the relationship between lenders and borrowers, such as the relationship between different contributors of capital to the organization of the firm, human capital and financial capital. But there's a question how far that one takes, that the point takes one with respect to the issue that we're investigating. I don't know whether you have any additional thoughts on this, Jens.
So I really love this question. So I think that's actually a very fertile ground to think about, right? So time horizon, and I want to take this question in a slightly different direction, right? So one question you might ask as well. So let's assume that we're interested in the time horizon of management. How is codetermination going to impact it? Well, it's going to depend on part, right? So, for example, right? So what's the age structure of the workers, right? So if there's a lot of young workers, right, they have a long-term interest in the survival of the company. If the workers tend to be on the older side, then maybe, they don't care. But then it could be drastically different if you have firm-based pension plans, right? So you have to think a little bit about, well, how these guys' retirement plans look like, right? If I have firm-based pension plans, then the long-term survival of the firm, can be very relevant. If it's all public pensions, then, that's less of a concern. So I think there's fertile grounds to think about there. I also kind of like the idea, so we probably can do more about on the issue of monitoring, which is kind of popped up, right? So you might think about, so if you think about, institutional lenders as a monitoring service, right? And that kind of came to the surface there. So the question really is, so, one of the potential benefits of codetermination arguably is that you have an additional monitoring level, right? These employees know what's going on in the firm and they can, and so the question is that additional level more necessary in Germany, or is it more necessary in the US? So my own cynical view was that the US capital market system is just a little better, more rigorous. There's more scrutiny. That was my, I've lived here for a long time, and here is the US. So I figured that, well, maybe that's what the Germans needed more. But now sort of the bank system is interesting, right? So you might make the case that banks are also a monitoring system. So maybe, on that level, maybe the Germans need a little less. So there's something we can think about there. But that's a fascinating, whole set of fascinating issues.
Okay. Now the next question is by, I think this is, let's see, is it John or Josh? Probably John. What impact would codetermination be expected to have on the time horizon of board decision making? Now, based on the assumption that employee representatives are primarily interested in maintaining the level of jobs in a particular firm, one would expect probably that it would rather have an effect towards a more long-term view of the corporation as opposed to maximizing short-term gains. How that is related or could be related to the issue of the types of investments that are made or not made is another question. That doesn't necessarily mean making only investments that exhibit a very, very low risk level. So I don't think that there is a direct connection between these two things, but probably it would be right to say that one would assume that a more long-term perspective would be inserted. Jens, do you have any?
I think I may have partially, sorry, I keep reading the screen while I'm listening to things. I may have partially jumbled the two questions. So I think that the time horizon will very much depend on the specific institutional setup, including, again, retirement systems, et cetera.
Okay. What does the composition, that's Luca, of the workforce in today's US corporation tell us about the benefits of codetermination? with manufacturing done mainly elsewhere in intellectual property and services as the main products made in the US, that the system designed for large manufacturing firms make more or less sense? Again, if you, to take up something that Jens has said, if you adopt a kind of cynical view, you might say, well, given that manufacturing has more or less disappeared from the United States, the damage that would be done by codetermination is lower than we might expect, because the damage would be done primarily to large corporations which have a significant manufacturing component. I wonder, Jens, what you say to this?
Yeah, I don't have strong views. You know, I imagine that, yeah, I need to think about this further, I think.
Okay. Then Julian, or Julie, Julian, I think, do you think that the introduction of codetermination is only possible if the shareholder primacy approach is abandoned? It seems contradictory to ask the directors who represent the employees to maximize shareholder value. You're probably right. There is a nexus between these two policy debates about what kind of goals should the corporation pursue. Should shareholder value be the maxim that clearly dominates, or should it be a more stakeholder-oriented approach that takes into account the effects on other stakeholders in the corporation? This debate is clearly linked to the debate about the introducing a mandatory codetermination on the board level, and we link actually these two debates in the introduction to the paper, and they are also linked to some extent in the specific proposals made by Warren and Sanders. However, there are various ways to justify mandatory codetermination rules, and some of them fit more easily in the debate about stakeholders versus shareholders than others. So, for example, the idea about democratizing all institutions in a society is driven by conceptions of what our polity should look like, and pretty strong and rich view of what the main elements of organizing our society should be in various institutions, not just political institutions. And I don't see that this kind of idea is necessarily very close to the idea of for whose benefit should a corporation be managed. But to come back to what I said at the beginning, there is a link here between these two debates, and certainly an overlap, and one may have a debate about how strong the overlap is. Then another point by Luca, what about the impact of codetermination on hedge fund activism? And there are two thoughts that you would like us to consider. First, codetermination would lead to larger boards to make sure that both employee representatives and short slates appointees make less damage. There's empirical evidence, somewhat more consistent than for other board characteristics, that large boards are worse than small ones. And secondly, in a board where shareholders only elect 55 to 60% of the board, shareholders may be more hesitant to vote short slates, as it would further balkanize the board. As an outcome, activist campaigns would become less likely to succeed. At the margin, there would be less activism. Good or bad, that I'll leave to you. Well, as far as the analysis is concerned that you're presenting, I don't see any flaw in it. So I would agree with what you're saying, basically. And the evaluation, the normative evaluation about whether activism is good or bad, that's of course a very different, very different field and a very different debate. And one can have very different views on this. So I tend to have a relatively skeptical view of the benefits of activist investors, but that may have a lot to do with my political inclinations, and that, of course, might well differ from the assessment of my co-author on this point.
I'm with you there. So, but I agree that in the US there certainly is a consensus that small is better in terms of board size, and you know, I think this goes back to something we brought up earlier, right? So a lot of the US corporate laws is built around a very involved, very active board. And so anything that would undermine the functionality of the board could potentially carry very large costs, and codetermination certainly, you know, would lead to larger boards, or, you know, at least that's what it's done in Europe and in Germany in particular.
Okay. Then there's an interesting question by Oren. What do we know about US workers gaining access to the board by their pension funds investing in their own companies? Now, I leave that to you, John.
So there's two strands in the literature that kind of look at this, right? So first, there's the traditional form of sort of worker investment are ESOPs, employee stock option plans. And employee stock option plans really have a bad rep, and deservedly so, because they tend to combine having workers financially invested in their company, which is bad from a risk diversification perspective, given that they already have their job tied up there, and at the same time notoriously give them less voice than they should, right? So ESOPs, you know, sort of combine the worst of two worlds, right? No diversification and yet no voice, really. So that's, you know, nobody likes ESOPs that I know of. And then there's a newer strand of the literature by a young man at well, young is relative, but a fellow at Boston University, David, and then I'm blanking on the last name, who said that really what really workers should do is, you know, they should use their clout via pension funds, not via ESOPs, but via sort of, you know, real pension funds, you know, CalPERS, whatever, to really push management towards a more worker-friendly direction. And, you know, the reason that hasn't been taking off so much is because, in part, right, that would be illegal under current law, right? So if somebody explicitly used their power as a large shareholder to push for the peculiar interests of workers as a subtype of creditors, right, they would likely run afoul of Delaware fiduciary duties. But that's certainly something that has been talked about in academia, right? So it's been talked about that workers should instrumentalize pension funds to gain a voice in corporate boards. It just hasn't been, you know, it's not been something that's been observed much as a current phenomenon.
Okay. Ewan has put a question in the chat that you might wish to discuss with us orally. So I wonder whether you would like to come in at this point.
Yeah, could I ask a question? I've had my virtual hand up. Thanks for the very interesting paper. It's very thought-provoking. There's a whole bunch of comments. I think there's a really interesting history pre-World War II about codetermination, which often isn't that well known. But in fact, the first board codetermination law was 1922. And it was even part of the Weimar Constitution in 1919. Came from a big collective agreement between capital and labor at the end of the the war. But the question that I want to pose, to make it a bit more general, is that your paper talks a lot about the importance of shareholder value, and you talk about Delaware law. I don't read Delaware law as entrenching shareholder value in the Newmark case, but I mean, we can recognize that most Delaware corporations do sort of pursue that because of their boards, who appoints them on the board. But the Warren and Sanders plans, their goals are not oriented towards shareholder value, but much more to tackling inequality and increasing overall prosperity. So I'm wondering, you know, if you wanted to argue against why their plans would be a good fit, why not develop an argument, or try to develop an argument around their own goals, you know, sort of like an imminent critique. And for that, I'll just post the link here. There's, I agree with you that empirical research is not conclusive, but there's some more research recently. I'm having trouble posting the link. In the International Labour Review in 2019. The Centre for Business Research has got a database of 117 countries and labour laws, including codetermination. And their most recent paper suggests that all kinds of labour laws, but including codetermination, decreases unemployment, increases employment, leads to a larger share of labour income. And of course, those are the things that Sanders and Warren are probably interested in, and maybe even most Americans. So why not try to address the goals that they think are important too?
Well, because it was, let me just try, because it would be a different project, right? So the one thing is, can we criticize these proposals against the background of a system of rules and institutions which we take as a given, and which, as we suggest at the end of the paper, are unlikely to change, at least in the short and medium term? And I think the answer to this is yes. And that's sufficient, I think, for making a point that's worth noting. So unless you fundamentally change the institutional environment, you'll run into a problem. Now, the kind of project that you're suggesting is another, of course, also interesting project. If you can show that maybe, given the goals that they set themselves for introducing a codetermination regime, it falls, it doesn't achieve these goals for whatever reasons you're able to come up with, or it is inconsistent, etc. That will be another blow to the proposals. And of course, you can pursue that line of investigation as well, but that's on our line of investigation. That's how I would respond. I wonder, Jens, do you have any additional comments on this?
No, I absolutely agree. So, you know, our project, you know, part of what's driving that is when Bernie Sanders pulled for codetermination, right? He said, look, it's working great in Germany, right? There's no reason why it wouldn't work here, right? So if you read his plan, right? So, you know, we were going to say, look, well, yeah, it may work in Germany to some extent, but there's reasons to think that that's not easily transplantable, right? So that's really what we're trying to do with the paper. Now, obviously, there are other super interesting questions, right? So, you know, if you're Elizabeth Warren, is codetermination a plausible piece of your agenda? Unrelated to the costs it may have, but that's not the question we're tackling here.
On the other point that you made very quickly, Ewan, I wasn't aware of what you mentioned about the law or proposed legislation in 1922 in the Weimar Republic. So if you could send us some kind of information on that, that would be much appreciated. So apparently,
yeah, sure. There's a link in the chat, but I can send it to you as well. It was called the Aufsichtsratsgesetz, and it was a full codetermination law. Oxford University has a codetermination law from 1854.
Thank you.
Anyone would like to ask further questions? Paul.
Yes, may I?
Sure.
So what strikes me as odd about this proposal in the States is that it's picking up only one of the elements in the German system of employee representation in relation to corporate policy. That is to say, it's picking up the board level staff, but not the works councils or collective bargaining on a multi-employer basis outside the firm. And I think everybody who's looked at the German system is of the opinion, though they have different views as to how it happens, that the central impact of codetermination depends upon the interrelationship of these three systems. As I say, people are already always very clear about how these three bits interrelate to one another, but that the interrelationship is crucial seems to be agreed. So if in the States the proposal is just to take one element, isn't it possible that both the benefits and the costs of this proposal would be very much less than they are in Germany?
So certainly, first of all, we completely agree with you. I think that really sort of picking out board level codetermination is odd in the sense that it's only part of the system. I would also argue that, you know, it's an odd way to start because sort of the works council, right, and they sort of you know, that level of codetermination is arguably the more natural first step, right? So it's kind of odd to start at the top when you can actually have a system that starts at the bottom. All right. Now, there would also be, you know, I think the reason why they're doing it, maybe that first, is that, you know, by and large, U.S. voters don't like what they perceive as socialism so much, but they also don't like big business. You know, there's sort of and so, you know, selling board level codetermination for very large companies, right? That sort of appeals to the, you know, skepticism vis-a-vis big business part, whereas selling, you know, the Works Council Act, that would be much harder because everybody loves small business in the U.S., right? And that is not so much tied to big business, right? So I think that explains what's going on there as a part of the political economy story. You know, I think this may be a very good avenue which to expand our research. I'm not sure we could do it in this paper, but asking as well, how would copying the Works Council Act play out in the United States? And, you know, I don't have a great off-the-cuff answer to your question of, you know, would this substantially, you know, would this mean fewer costs and fewer benefits if we don't do it? How would it change? I would have to think in depth about, you know, what are the costs and benefits of also taking these other parts.
Let me add something to what Jens has said about these different elements. Now, what you also might say is it really true that these three elements need to go hand in hand to be effective, that this is one system that should be broken apart? And what makes me ask this question is the following observation. In Germany, it is a quite common phenomenon that actually many firms who are required to have a works council by law don't have a works council. So once you've got more than 5 employees, the company has to have a works council by order of the law. Now, that doesn't happen in many firms, and it doesn't happen because the employees don't self-organize and just elect a works council. Though they are under an obligation to do so, they don't do it. Of course, they don't do it because there's also pressure by those who run the firm that they don't do it because they don't like works councils. But the reason they don't like works councils in small and medium enterprises may partly have to do with how well a firm is positioned to swallow the transactions costs and the prolonged haggling that is a consequence of having institutions like codetermination, be it on the shop level or on the board level. And codetermination on the board level, affecting large corporations, of course, only, may in a sense be less controversial than codetermination on the shop level in Works Council, because it throws so much transaction costs into small and medium-sized enterprises in particular. And that may be an economic rationale, or some kind of idea at least, why it's not necessarily a system that has to go with all elements and components, and it may actually be quite prudent to start at the top.
Can I just ask whether that's true of the range of publicly traded companies that are subject to the US proposal? I mean, is it true that they have co-determination at board level and no works councils? I mean, I know that overall across German industry as a whole, the percentage of companies without works councils is relatively high, but is it true of the particular population we're looking at?
So it's not true for, you know, publicly traded corporations. I think, as far as I know, they all have more or less works councils. I think what Horst was referring to was smaller firms that are, you know, they don't need to have co-determination at the board level. They're supposed to have co-determination at the works council level, but, you know, they kind of skirt the rules there.
There is no one else. I have a question which more or less relates to these points about complementarities, which is if you don't have these other instruments to protect workers and their dignity and tackle inequalities and so on, and you basically put a strong emphasis on codetermination, which may not exactly be the case with the broader proposals of these two senators, but it's your focus. So you say you cannot just rely on codetermination. Then perhaps the type of codetermination becomes even more relevant, and this is definitely not quasi-parity codetermination. It's between 1/3 and 50%, but definitely it won't give the employees representative much power within the board, because they will be outnumbered at any vote. And without a culture of co-determination in the substantive sense, it's unlikely that there will be a search for consensus. So if that is the case, then the benefits that you outline in the paper are unlikely to be achieved anyway. And if there are no benefits, then you only have the costs. So I didn't see this argument spelled out in the paper. I wonder whether you can make any use of it.
So I'm not sure I've gotten all of your question, because my sound was breaking up a little in the middle. But what I understood you were saying is, you know, they don't give you majority control, or they only give you a minority stake in the board, and you may actually have less power in the U.S. for employee representatives, and they may essentially be, without real ability to affect change, which means you may still have some of the costs but not the benefits. Is that sort of where we're going? Okay, so I got that part right. So first of all, I think you're certainly right to some extent, right? The one thing where I'm not entirely sure, again, sort of in the US, we're a very active takeover scene, right? And in the takeover context, it's very essential to gain control of the target board very quickly. Now, if you imagine that the employee representatives, even if they're a minority, could play a crucial role in gaining that control of the target board, then you might imagine them having power in at least some circumstances, and they might leverage that power to gain concessions for the time when they're no longer, the dominating force. So it's a little hard to predict. So I agree with you that yes, they're likely, especially on a day-to-day basis, they're likely to have less power in a more polarized world, and so they may not have much impact. But then it's sort of these rare, well, not super rare, but unusual, but highly economically significant contexts, such as takeovers, where they may suddenly have a disproportionate role, which may translate into some substantial power. And it's hard to predict exactly what's going to go on there.
One further thought by me on this, Luca. Now, if I understand it correctly, what you said is if the rule is that it's just 1/3 or less than 50% co-determination, then workers cannot really affect what's going on the board. So the positive things that we mentioned would not materialize, but we would have all the negative things anyway. So it wouldn't be very sensible to do this. Now, what we didn't discuss in the paper, as far as the positive effects of co-determination are concerned, are all non-pecuniary benefits that co-determination has. We touched upon the issue of democratization, and we spoke a little bit about human dignity, etc. There are, of course, others, such as the notion of introducing or fostering social peace within the firm, but also in a more broader sense. Then there's the issue of information sharing and legitimizing corporate action with respect to the stakeholders in the corporation, but also in the broader sense. Now, all these intangible things are, of course, hard to quantify anyway. And that's my point. They are not necessarily connected to the level of co-determination or linearly connected to the level of co-determination that you imagine. So they may materialize to a significant degree, even if you have only a 30% or 40% co-determination.
Maybe, okay. Yeah, there are no other raised hands or questions, I think, and it's 3 minutes to 2. So we can, I think, thank the speakers and the audience as well, but especially the speakers for this great presentation, excellent paper. And we would clap our hands if we were in the same room, which we won't do other than metaphorically.